A mask ban, protest fee, and collective punishment. That's how the government's clamping down on protest in the new bill. But what exactly is a protest? Protests are basically freedom of speech in action. It's a tool that's used by those who lack political and economic power to communicate their legitimate concerns. The government's unmerited crackdown on Finance Bill 2024 protesters unearthed the flagrant constitutional violations of protesters' rights, which included arbitrary arrest, and forced disappearances and media harassment. This lifted the veil of Kenya's stanchion of democracy and exposed the grim statistics of Kenya's rank worldwide, as it ranks 92 out of 167 countries and ranks 14 in the sub-Saharan Africa on the Democracy Index. Kenya equally ranks 93 on the Human Freedom Index according to the Cato Institute 2023 report, which centers on personal, civil, political, and economic freedom and whose metric system encompasses indicators such as respect for the rule of law, freedom of assembly, freedom of association, freedom of civil society organizations, freedom of expression, and freedom of movement, amongst other indicators. Further, Kenya has a low-ranking score on Public Participation Index, which can be attested by the numerous acts of parliament which have been declared unconstitutional by the courts. This has therefore resulted in Kenyans being left on the latches of the streets to express themselves as a semblance of indirect participation in their political affairs, and for the clarion call of good governance of their country. And now there's a bill that seeks to clamp down on protesters with protest fees and punitive punishment. This is the Assemblies and Demonstration Bill 2024. Salient features of this bill cast a dark, ominous cloud over the freedom of assembly and poses a calamitous chill effect on freedom of speech. The bill, in the interest of maintaining public order and public safety, required the organizer of a protest to notify the regulating officer of a planned protest within the prescribed timeline of not less than 3 days from the planned protest and not more than 14 days from the protest. Further, the organizer should furnish the regulating officer with the following particulars: the date of the protest, the time of the protest, that is between 6 a.m. and 6 p.m., the proposed site of assembly or the proposed route if there is a public procession. Further, the organizer of a protest is required to furnish their name and physical address. They are equally required to be present throughout the assembly and assist the police in maintaining law and order. Failure to issue a notice to the regulating officer attracts a criminal liability, as Section 14 of the bill criminalizes anyone who convenes an assembly without a notice or without adequate notice. The section thereafter imposes a 100k fine or a 1-year imprisonment. However, this section single-handedly expedites the transition pipeline from an organizer/protester to a pre-trial detainee due to the extortionate fine and punitive punishment. The quagmire is, in the spirit of restorative justice, is the criminalization of the failure to issue a notice or give adequate notice to the regulating officer the best deterrent, or is a threat of punishment the only alternative to incentivize people to issue notice? Lastly, is the administrative fine of 100,000 Kenyan shillings or the 1-year imprisonment necessary and proportionate to what is at best a misdemeanor offense? Statistically, pre-trial detainees make up nearly half of the prison population, and this is data from the State Department of Correctional Services. And this is due to sections of arcane laws which endorse punitive punishments over misdemeanor or petty offenses. This is despite Kenya having ratified international treaties that support non-custodial measures such as probation, community service, suspended sentences, absolute or conditional discharge. Further, anyone who participates in a protest or demonstrations in which a notice wasn't issued or adequate notice was not issued will be criminally held liable, as they are partaking in an unlawful assembly which can escalate into a riot, which is an offense under Section 78 and 79 of the Penal Code, which impose a 1-year prison sentence. However, there are better alternatives to this which do not include a rise in prison population, which starts with the decriminalization of certain petty offenses or misdemeanor offenses, such as an offense of breach of peace or being drunk and disorderly. These two offenses have been used as trumped-up charges against protesters in this recent Maandamano protest. Further, there are alternatives to trial and prosecution, such as committing people to diversion programs, which would also avert the pre-trial detainee issue that leads to overcrowding in prison. And lastly is the implementation of alternatives to prison sentences, that is through the non-custodial measures to which we are bound to due to the international treaties such as the United Nations Standard Minimum Rules for Non-Custodial Measures, dubbed the Tokyo Rules, the Bangkok Rules, which offer non-custodial measures for women offenders and the treatment of women prisoners, and lastly, in the instance of children, Article 53 of our Constitution, the Riyadh Guidelines, the Beijing Rules, all advocate for a child-centered juvenile justice system, which seeks to have children averted from the criminal justice system and the adverse effects of a criminal record. In addition, a South African court has already pronounced itself on the issue, in which it declared that the criminalization of the failure to issue a notice of a planned protest as required under Section 12 of the Regulation of Gatherings Act 1993 was unconstitutional, as it ran afoul of Section 17 of their Constitution that guarantees freedom of assembly. The court held that the criminalization was not necessary or proportionate to the offense, and further that the government had failed to prove that they had exhausted all other measures to incentivize people to issue notices. The court found that the criminalization aspect acted more as a deterrent over the exercise of the freedom of assembly. This is because the Regulation of Gathering Act was enacted by the apartheid South African government in 1993 as they sought to impede efforts of the South Africans achieving self-determination and fully exercising their civil and political rights, as they were inching closer to independence, which they later gained the next year in 1994. Given that timeline, it's evident that the South African apartheid government enacted the Regulations of Gatherings Act to curtail freedom of assembly in a futile attempt at diminishing South Africans' efforts of gaining independence. Further, this bill proposes giving police a carte blanche in prohibiting the authorization of a protest or stopping a protest under the guise that the protest poses a present or imminent danger to the breach of peace or public order. However, the Human Rights Committee General Comment Number 37 affirms that states cannot automatically prohibit a protest based on a perceived threat of violence or risk of imminent danger. The police must first satisfy that they've conducted an objective risk assessment. They must also specify the anticipated risk or violence. They must also prove that they are unable to contain such a protest, even with further deployment of police. Lastly, they must prove that they have exhausted all less restrictive measures in comparison to prohibiting the protest. This arcane bill also seemingly imposes a protest fee that a regulating officer may set as a condition for holding a demonstration. This perceived protest fee is associated with the payment cost of cleaning up, which may arise after the holding of an assembly. However, this section is unreasonable and unjustifiable as Kenyans already pay taxes. Further, there is a lack of certainty as there is no prescribed minimum or maximum limit of the payment cost, which can lead to deterring protests due to the imposition of a financial burden. Lastly, the other least restrictive measures, such as counties ensuring that they have in place adequate waste disposal bins to avoid littering during the protest. We now shift gears to the more controversial aspects of this bill, such as in Section 11, which prohibits wearing a disguise, a mask, or any apparel which obscures your face or prevents identification. Now, face masks range from N95 masks, visors, gas masks, balaclavas, and even mascots. In fact, a man dressed up as a panda, dubbed Anoko Panda, at a student-led protest in Canada, challenged an anti-face mask law at the Court of Appeal in Canada and actually won. And here's why. This section is so broad and vague as it ropes in those who wear apparel that obscures their face or prevents identification due to religious reasons, such as Muslims who wear hijab at a protest. It also ropes in health-trained professionals wearing masks treating injured protesters at an assembly. And lastly, those wearing a mask due to public health issues or medical conditions. Therefore, this section is excessive, arbitrary, and unreasonable. The problem of this section is the imposition of the blanket ban. There should be some exceptions. This was further elucidated by a high court in Hong Kong following the mass protest that prompted the government to invoke a British colonial-era emergency regulation ordinance that prohibited facial covering at a protest. The High Court held that the blanket ban on face masks failed to meet the necessity and proportionality test required in limiting or restricting human rights, as a blanket ban encompassed not only the unlawful assembly but also lawful assembly. This High Court ruling ruffled the government's feathers, and they appealed to the Court of Appeal, which declared that the mask bans were legal. However, their ban was only applicable to unlawful assemblies. Lastly, the most controversial aspect of this bill is that in Section 12, it proposes collective punishment, which in my opinion is a logical fallacy that is a hasty generalization that anyone who attends a protest is a criminal, as the bill seeks in Section 12 to hold everyone who attends the protest jointly and severally liable for any property damage. Further, this cast a wide net approach has the possibility of deterring protesters from attending protests due to fear of incurring criminal liability over property damage without proof that they had any criminal intent to cause a property damage or that they actually conducted themselves in a manner that led to damaging property. Further, this section will ultimately lead to protesters, organizers, and organizations be at the mercy of SLAPS, that is strategic litigation against public participation, as those who have suffered property damage will sue on the cost of defending such a lawsuit may cost an arm and a leg. Moreover, this negligence-based liability imposed on organizers, protesters, or organizations is against the Constitution as it seeks to penalize people based on association, which essentially means you're also criminalizing the assembly. Further, this standard of liability is based on vagueness and uncertainty. This is because an organizer, an organization, or a protester cannot reasonably predict that there are people who will infiltrate the protest for nefarious reasons, causing violence that will equally result to property damage. It's equally unreasonable to hold protesters to such a standard due to the impossibility of expecting a protester to be seized of every activity that takes place at a protest, as it will be a Herculean task to impose such a liability due to unforeseeability. The problem with this section is that it deflects liability to the protester, organizer, or organization and not the actual perpetrator of the crime, who should be the one who incurs criminal liability as an individual. Finally, I'm not disputing that some protests have led to destruction and some regulation may help alleviate that, but the essence of this video is whether this bill passes the constitutional muster.